Good afternoon, everyone. We're going to go ahead and get started. Please continue to get pizza and take your seats. I want to thank you all for being here and for committing your lunch hour to learning from a true reproductive justice leader about these critical issues. My name is Katie Cullum, and I am a third-year student here and an officer of Mauer's chapter of the American Constitution Society. It has been my pleasure to serve as an officer for the past 3 years and a joy to work with and learn from our dynamic, creative, and talented progressive peers. ACS is the umbrella progressive organization here at Mauer. As part of a national network, ACS seeks to advance progressive values in constitutional, legal, and policy development. ACS operates from the fundamental beliefs that the Constitution is a living document and that the law can be and should be a tool to improve the lives of all people, regardless of their position in society. Here at Mauer, our ACS chapter has the profound privilege of having Professor Dawn Johnson as our faculty advisor. From all of us on the board, I want to thank Professor Johnson for her leadership, mentorship, and support that has made another incredibly successful year possible. It is not lost on any of us how lucky we are to have you here. In Indiana, we have also been uniquely burdened by living in a laboratory of anti-progressive policies. In the past 3 years alone, Hoosiers and those around the country have experienced the outrage, grief, shame, and fear caused by such policies. To illustrate just a few, these have included the criminalization of pregnancy, and in particular, the startling case of Purvi Patel, Indiana's Religious Freedom Restoration Act, Indiana's anti-trans bathroom bills, and the ongoing dearth of protections of our queer communities, and most recently, Indiana's latest draconian abortion restrictions, ones that challenge the very core of Roe v. Wade. I would also offer, however, that being in Indiana presents similarly unique opportunities. As lawyers and soon-to-be lawyers, we have the powerful privilege to fight these discriminatory restrictions from within the law. We can engage in activism and advocacy to effect direct change in our home state, where dedication to progressive values and progressive change are desperately needed. Today presents one such unique opportunity to learn from Louise Melling, a lead engineer of the pro-choice movement who has dedicated her work and her brilliant mind to defend and expand reproductive rights and justice for all persons affected by anti-choice policies. Louise Melling graduated from Oberlin College before receiving her J.D. from Yale Law School. After law school, Ms. Melling clerked for the Southern District of New York and spent time in private practice before accepting the role of director of the ACLU's Reproductive Freedom Project, where she led the fight for a holistic vision of reproductive freedom, working on nationwide litigation, research, public engagement, and legislative advocacy. Ms. Melling has continued the sustained dedication to reproductive justice and now acts as a deputy legal director of the ACLU and the director of its Center for Liberty. In this capacity, Ms. Melling is a leading voice, both in advocacy and scholarship, on issues of reproductive freedom, women's rights, rights of LGBTQ persons, and freedom of religion and belief. You may recognize Ms. Melling's scholarship from any number of law review articles or from her many appearances in media and publications like the New York Times and the Washington Post. We are truly fortunate to have Ms. Melling here with us today to continue and broaden our ongoing discussion surrounding religious freedom and the implication of religious refusal laws. Ms. Melling will discuss why religious refusals to provide reproductive health care constitutes discrimination. Please join me in welcoming Louise Melling.
Thank you all so much. It's a total privilege to be here. I'm incredibly delighted. I'll just say that I have one caveat to that, which is if I had the power of being the CEO of Salesforce, or if I were Bruce Springsteen, I might instead have said, I'm not traveling to Indiana in light of the new law that passed, or I'm not traveling to Indiana in light of the prosecution of Ms. Patel. I would have tried to summon up the forces, the way we're trying to see the forces acting in Mississippi and North Carolina. I'm proud of those companies like today Deutsche Bank, AT&T, Toyota, Salesforce, all those companies stepping up and saying, that's about discrimination. We won't do business with states that discriminate. But that's what's happening here, too, in Indiana, in terms of restrictions on access to abortion. That, too, is about discrimination. That's the predicate of what I want to talk to you about today, is why we should rethink how we see that. I'm going to talk about it in the context of what I call religious refusals. Not everyday dinner parlance, but when I talk about religious refusals, what I'm talking about is those occasions where an institution, think a hospital, a pharmacy, an insurance company, or an individual, refuses to provide services because of religious beliefs. I'm going to talk about it in that context because that's where I just spend a lot of my time thinking. You heard that I have this intersectional work. I look at religion and I look at LGBT rights. I look at women's rights. I look at reproductive rights. But what I'm going to talk about isn't limited in any sense in terms of an analysis to that context of religious exemptions. So we'll start with another Indiana story, which is your Indiana story of last year when Governor Pence signed into law Indiana's Religious Freedom Restoration Act. When that happened, it wasn't yet the norm for all of American businesses to act in an outcry. So what happened here in Indiana was striking both for what happened and for what didn't happen. What happened, as you all well know, is that you saw major companies stepping up and saying this was discrimination. You saw Eli Lilly, Apple, Salesforce, Gen Con. You saw the National Collegiate Athletic Association standing up. They all spoke about discrimination. They all spoke about discrimination against LGBT people. Then there was a fix in the face of that, or a so-called fix. It's not really a fix. We can talk about that later. But then there was a fix, and that fix, too, was about LGBT people. It was an amazing moment in terms of America's transition and in terms of people coming to understand and respect what was at stake here. But what was also striking was the complete absence of any conversation about the consequences of the Religious Freedom Restoration Act for women. There was no outcry, even though to date the only group I believe has yet been concretely hurt is women. There was no talk about Hobby Lobby, which had by that time been decided, where for-profit businesses successfully argued, using RFRA, that any requirement that they have to provide insurance coverage for contraception violated their religious liberty. There was no fix proposed. There was no fix, so-called, enacted to address the consequences of Religious Freedom Act for women, and for women in particular who seek contraception, sterilization, or abortion. It was, as I say, all quiet on the reproductive rights front. Today I want to call for a change in that. I want to call for a change in how we think about those refusals to provide the services women seek, relating to how we think about families and our lives. I want us to question those refusals in the same way as we question those refusals of businesses to serve couples, for example, because they're same-sex, or of hospitals to serve people because they're transgender. I'm going to do that by talking about a few examples and sort of raising questions about how I think we should think about that, or what questions we're not publicly asking. Then I want to talk about why I think there's a difference, and then I want to talk about why it matters. So let's start with the examples. I'm going to go extreme first. I'm going to talk to you about an extreme example because I think it shows you where what's otherwise happening goes. Does that make sense? So this is an example in a case coming out of New Jersey where several years ago, nurses working at a public hospital filed a lawsuit against the hospital seeking a declaration that they should not be required to provide pre- or post-abortion care to women. Got that? The question isn't whether they participate in the abortion. The question isn't whether they're in ER. The question is whether they provide pre- or post services. They charge that any requirement that they assist in any manner would burden their rights to free exercise. They objected to tasks that included the following: telling the patient to change into a gown, checking to see if she had a ride home, checking her temperature, asking if she was nauseated, reviewing discharge instructions, and making a follow-up appointment. One nurse talking about the post-abortion care requirements said in an affidavit, "I have come to the conviction that my religious and moral beliefs against performing health services on abortion cases includes an objection to assisting health services during final checkout as well, since they are necessary for the abortion process." It's an argument similar to the argument that's before the Supreme Court right now in the contraception case, the Zubik case, where nonprofit agencies are requiring that they shouldn't even have to fill out a form saying they object to having their insurance cover abortion, contraception. In that sense, those nurses, like the nonprofits in Zubik, are arguing that any act I take that makes this possible makes me complicit in a sin. Or as I think, any act I take might help enable that woman to get the care that she's seeking. My question about that case is, would we ever tolerate that kind of notion in any other context? What would we say if this were a case of a woman seeking in vitro fertilization services? What would we say if this were a doctor who said, I refuse to touch any woman who's not a member of my family? What would we say if this were a transgender person seeking transition services? I think in those other contexts, we would at least readily understand that the refusal to provide care in those situations comes with a stigma. I don't see any other way for us to understand, in particular, the refusal to provide care following a procedure. But what about the refusals to provide the services before? Those are tasks nurses routinely perform. Checking in, making sure you have a ride home. It's not the task. It's the person. In those cases, I think we could understand that what the nurses in essence are saying is that that patient is untouchable. I shall have nothing to do with her. In the reproductive rights context, in the context of abortion, I think we should be seeing it similarly. But now let's go from thinking about those nurses to thinking about the institutions. What about the hospital that refuses to permit abortions to be performed? Now here, you all, I don't know what you've already learned in con law, you just have to put aside the fact that I know that today public hospitals can ban abortions. Crazy, but true under the federal Constitution. But I still think the issue isn't what does the law say, the issue is what kind of questions we should ask, because we should be challenging ourselves to think about what's possible and what the harms are of our current laws. What about the pharmacy that refused to fill a prescription for women who are coming in seeking birth control? On Monday, just as an aside, the Supreme Court will probably, announce whether or not it's granting cert in a case of a pharmacy that argues it should not have to provide emergency contraception because of its religious beliefs. Or, back to Zubik, what about the company that refuses to provide insurance coverage for contraception for women? Those are all cases where you have institutions turning away women because of what they're seeking. In the context today of a bakery that refuses to provide a cake for same-sex couples, we increasingly understand that that is not about a cake. The question increasingly isn't, couldn't you just get the cake somewhere else? As we see from the conversation here in Indiana, as we see from the conversation surrounding Mississippi now, we increasingly understand that what's at stake there is dignity. What's at stake there is being turned away because of who you are. The focus isn't on the cake, the focus is on the people. In the case of the hospital, in the case of the pharmacy, in the case of the insurance company, why aren't we making that transition? Why are we seeing that as about abortion, contraception, and not about women, and is about who we are as women and how we control and decide our lives? Now we'll go back and think about the staff at the public hospitals. They're at a public hospital, those nurses I talked about. I think it was just last year. It feels like a long time ago. Just last year, our papers were full of conversations about Kim Davis. You all remember Kim Davis? The county clerk who was refusing to provide licenses because those licenses, marriage licenses, could go to same-sex couples. In that context, we had a robust conversation about what it would mean for a public official to assert a claim of conscience. Can you assert that sort of private role when you're acting as a government official? We had a robust conversation about what it meant for a state actor to engage in discrimination. That conversation has been limited, interestingly enough, to sort of the clerks, and it's kind of amazing here I'm in Indiana because the Seventh Circuit, for example, addressed some years ago, maybe 20 almost, or no, 10, or 20 closer, about a police officer who said, my conscience prohibits me from from serving outside an abortion clinic to make sure everything is safe. I can't do that. The police department then offered this police officer the opportunity to transfer. It was an accommodation as a matter of employment law. The officer refused to take that and was fired. He subsequently filed a suit charging the police department with religious discrimination because they didn't accommodate his beliefs. Judge Posner, in the context of that decision, emphasized that the police officer was a public officer with a public duty. Judge Posner reasoned, when they call the police, they can't worry about whether the police are going to refuse to offer you protection because you're black, because you're Jewish, because you're a Muslim. The Third Circuit extended that reasoning in the context of a public hospital nurse who refused to provide an emergency abortion because of her faith. In that context, the court said, public trust and confidence requires that a public hospital's health practitioners with professional obligations to care for the sick and injured will provide treatment in time of emergency. If we go back to those nurses in New Jersey, why aren't we asking the question about what, as public officers charged with treating us, what obligations they owe to us, the same way as we're thinking about the public officer, the police officer, the same way we're thinking about Kim Davis. I could continue. The world abounds with opportunities to provide these comparisons, particularly in today's robust conversation. But now I'm going to sort of ask the question, so why? Why is it that our conversations look so radically different when we think about these two different spheres? So I'm going to offer three possibilities. One, and I think it is kind of most fundamental, is we just accept it. We just accept the notion that doctors, hospitals, almost anybody, can refuse to engage when it comes to women seeking abortion services or women seeking now, much to my surprise, even contraception services. And I think we do that in significant part because this notion of refusal is what I often refer to as, it's like the wallpaper. It's unintrusive, it's just there. It has become the backdrop against which we live our lives. And that's because we've had these laws, we've had this regime for 40 years now. In 1973, just months after Roe versus Wade was announced, Congress passed a law that said neither individuals or institutions can be required, because they get federal funding, to permit abortions or sterilizations to go forward. It's the reverse of how we usually think about government funding and what the power is that comes with it. By July of 1973, mere months after Roe was decided, 15 states had already passed laws permitting institutions to refuse to provide abortions. By the close of 74, it was up to 27. Today, it's more than 40. That is the landscape. But that's only the beginning of the story, in the sense that it's not as if having those laws quieted the country. Congress passed a law subsequently, sort of one of my personal favorites. I really hope it will be sort of that this version will end before I end my legal career, but I'm doubtful. This is a measure that Congress passed that says, as a matter of federal law, federal and state and local agencies risk losing federal dollars if they subject any institution or individual healthcare entity to discrimination on the basis that they do not provide, pay for, provide coverage of, or refer for abortions. Normally in that context, we would be talking about the federal government using its powers to end discrimination against people like women, like African Americans, like LGBT people. Here, we're talking about discrimination against institutions that refuse to provide a service that's constitutionally protected. That's where we've gone. And now we've gone so far as to talk about for-profit businesses, for example, that refuse to provide care. It's a very different story than what we're seeing happening now with LGBT rights in terms of what, as a nation, we seem to be prepared to accept. And it's a very different story than what we accepted in the context of the civil rights movement. It'll seem crazy, I think, fortunately, to say to this audience that at the time the Civil Rights Act of 1964 was going through Congress, there was an amendment offered and passed in one of the houses to say that institutions that objected for reasons of faith should be allowed not to comply. There were restaurants and schools that argued in court that it violated their religious freedom to integrate the races, to accept, for example, African Americans into their school or to serve African Americans in their restaurants. We understood that was discrimination, and as a nation we said no. But today it's as if we accept the religious refusals in the context of reproductive rights as a norm, just as we accept that it would be insane to accept anything like that in the context of integration and hopefully in LGBT rights. I think the fact that we have this norm of law has something to do with it. Now, I'm talking about refusals, but I just have to say, when we think about the norm, there's more to it than the question of refusals. The religious refusals notion, I think, was sort of the first thing that happened. The first event, really, that happened after Roe versus Wade, when we had all these states passing laws and the laws sort of sticking that said that institutions could refuse. But very soon thereafter, just a matter of years, we had the United States Supreme Court saying that it was permissible for the government to use its funds to refuse to support women who were seeking abortions. It was okay for the government to use its funds to favor childbirth over abortion. That's in the context of Medicaid funding, where the court ruled it was fine to exclude Medicaid coverage for abortion from the Medicaid program. Then we had the Supreme Court saying public hospitals could ban abortions. And then in Planned Parenthood versus Casey, we go from religious institutions to funding, and then we go to Planned Parenthood versus Casey, where the court extended to the doctrine to say that in general, the government can favor childbirth and discourage abortions as long as its discouragement doesn't constitute a substantial obstacle. I would posit in some sense that the refusals doctrine became one of the first ways in which we started to shun abortion and women who seek abortion. It's a lovely transition to my second point, which is that first it's our norms, but our norms have come to mean not only that we accept that you can refuse, but they've come to reinforce or put forward some view that abortion and the women who seek it and the people who provide it are immoral. I don't understand how else we can make sense of a rule that says that public hospitals can refuse to provide something that's protected by the Constitution. I don't understand how else we can understand the notion that the government can use its power to discourage exercise of a fundamental right. We know that the government acts in certain ways, consider voting, to discourage rights, but we don't openly say that they can go ahead and do that to favor one option over another in the constitutional balance. So I think that makes us, the notion that abortion has become so stigmatized, that the women who seek abortion and the doctors who provide abortion has become so stigmatized, makes it much, much easier for us to have a different conversation, or shall I say a lack of a robust conversation when it comes to religious refusals around reproductive health care. Third, at core, I think that the question, how we think about this issue of religious refusals in the context of reproductive rights is, it's still thought of, as I alluded to before, as about a service and not as about a class, not as about a protected group. So refusal, and you'll understand what I'm doing with the language here, refusal to facilitate an abortion is seen as being about a service, whereas refusal to provide a wedding cake is not seen as just about a cake, as I said before. In that instance, we understand it's about the people, and in that instance, we understand it's about discrimination. With reproductive rights, we miss the status. Even our language is different. That's true even for people like me and my colleagues. We talk about institutions refusing to provide abortions. We don't talk about institutions turning away women at the door because they're seeking abortions. We talk about pharmacies not filling prescriptions for contraception. We don't talk about pharmacies shutting the door on women because what they want is contraceptive services. Women are missing far too often from our image, our visual, and from our analysis. So I'm sure you can guess what's next. I think that's got to change. I think that has to change if we care about equality, if we care about non-discrimination in this country. We changed how we thought about LGBT rights. It's not as if this magically happened in 2000 and pick a year, 14. I'm going to point you, I'm actually going to talk about the law for a second. In the context, once upon a time, sodomy, it was perfectly fine to ban sodomy, for example. Case goes up to the United States Supreme Court. Sodomy law is defended on the grounds that it condemned certain sexual conduct, not because it condemned gay people. So 20 years ago, the United States Supreme Court in Bowers versus Hardwick framed the issue there, the challenge to the constitutionality of the sodomy ban, as saying that it was about whether there was a fundamental right of homosexuals to engage in sodomy. And it upheld the law in that context. But 15 years later, in Lawrence versus Texas, the court took a different tact. Referring back to that statement in Bowers, the court said, that statement shows the court's own failure to appreciate the extent of liberty at stake. To say that the issue in Bowers was simply about the right to engage in certain sexual conduct demeans the individual put forward, just as it would demean a married couple were it to be said that marriage is simply about the right to have sexual intercourse. I would say to you that to cast reproductive rights as simply as being about a good, about abortion, about contraception, about sterilization, is similarly a failure to appreciate the extent of the liberty at stake. The court in Lawrence talked about the issue there as being about marriage, procreation, contraception, family relationships, childbearing, and education. It was looking to Casey and talking about what was really at stake in terms of how it was going to understand the ban on sodomy. I think we have the same issue here. For women seeking abortion, for women seeking contraception, for women seeking sterilization, for women seeking control of your lives, what you have is at the heart of liberty a right to define our own existence in these contexts as we did in the context of Lawrence. It's not just a service. There are other ways. So the LGBT movement in this respect, in terms of, shows us that the transition in thinking can happen. And so there's still hope and work to be done in that respect. I think there's two other reasons, two other ways in which this is about discrimination that we can marshal, not just the sort of Lawrence analogy. But another is, I think it's come through already, and to me it's obvious, but I don't think it is always in the course of this discourse, which is reproductive health care, abortion, sterilization, birth control, critical to women's equality. But for that, how would women control? How would we control our decisions about childbearing, and thus about family, and thus about education, and thus about politics, and thus about sort of, shall I say, everything? Even the plurality in Planned Parenthood versus Casey recognized that, saying the ability of women to participate equally in society, in the economic and social life of the nation, has been facilitated by our ability to control our reproductive lives. I think there's another way in which it's discrimination, which may be less obvious, which is refusals to provide reproductive health care are rooted in gender stereotypes. When a provider shuts the door on a woman or turns away a woman because she's seeking birth control, or she's seeking abortion, or she's seeking a sterilization, she's sent away, I think, for reasons about stereotypes about what a woman should be. That the proper role for a woman is for her to become, if she's pregnant, is to have a child. It's to put aside her needs and her desires and to not be selfish. But long ago, in other contexts in the law, we rejected this vision. We rejected the idea, for example, that women could be excluded from the legal bar on the grounds that, and here I'm quoting the United States Supreme Court at a point when it said it was okay not to let women be in the bar, the paramount destiny and mission of women are to fulfill the noble and benign office of woman and mother. Much later, we rejected the notion that women can be presumptively exempt from juries on the grounds that a woman is still regarded as the center of home and family life. And more recently, in the context of abortion, the Supreme Court stated, talking about motherhood, that these sacrifices to become a mother have from the beginning of the human race been endured by women with a pride that ennobles her in the eyes of others, cannot alone be grounds for the state to insist that she makes the sacrifice. We've understood in other contexts that these limitations are about stereotypes. We've understood in other contexts that this is about perpetuating one way in which women are to be, similar to one way in which men are to be, another way in which marriage is to be. But we haven't yet done the work to carry that forward in the context of the current debates about when an insurance company, when a business can refuse to provide coverage. We haven't done the work yet in the context of whether a pharmacy can turn you away because of who you are. We haven't yet done that work in the context of when a nurse or when a hospital can turn a woman away because of who we are and because of how we're envisioning our life. the difference in how we think about this and whether we transform our thinking to at least ask the questions, the serious questions about what's at stake in the context of religious refusals and reproductive rights matters. Think back to the notion that government dollars can't be used in service of discriminating against an institution that refuses to provide abortion coverage. If we really cared and we really understood what this means for women, if we really understood this was about discrimination against women, government dollars would be used to not serve, not support hospitals that turn women away. Just as they're used to refuse to say that you can't, Medicare and Medicaid dollars were a big factor in desegregating hospitals in the late 60s under the Civil Rights Act. We would have a very different notion of discrimination and how our government functioned in this context. We would have a very different sense of shame for women as we struggle to find care. We would have a very different sense of our lives in terms of whether doors get shut on us. So this is my call. This is my call for you to ask yourselves when you hear about these cases. Ask yourselves what's at stake, and to change our vision about how we understand refusals in this context. So we'll have a different conversation when the next state passes a Religious Freedom Restoration Act. We'll have a different conversation, and it will matter for women, for our lives, for how we think about discrimination, and for how we think about equality. Thank you.